Hello guys, welcome to LawPutra YouTube channel. I am Bhavna here. Today we are going to discuss about top 5 case laws of professional misconduct under Advocates Act 1961. In every profession, there are certain professional ethics that need to be followed by every person who is into such profession. But the fact here is professional misconduct is a common aspect. The same thing we face in our advocate's life too. So let's see what Advocates Act 1961 talks about advocate misconduct under Advocates Act 1961 and what is professional misconduct. Okay, then let's see. If we know what is professional misconduct, then we can see the top 5 case laws about it. Okay, in simple terms, let's know what is professional misconduct. Professional misconduct means certain acts done by the persons which seem to be unfit for this profession as well as which are against the ethics in this field. Section 35 of Advocates Act deal with the professional misconduct of lawyers and advocates in India. Some of the instances of professional misconduct are dereliction of duty, professional negligence, misappropriation, changing sides, contempt of court and improper behavior before a magistrate, furnishing false information, giving improper advice, misleading the clients in the court, not speaking the truth, and moving application without information that a similar application has been rejected by another authority, suggesting the bribe to the court officials, and forcing the prosecution witness not to say the truth. These are the situations where professional misconduct might happen. Now let's move to the top 5 case laws in professional misconduct under Advocates Act 1961. The first case law we are going to discuss about is Bar Council of Andhra Pradesh versus Kurapati Satyanarayana, AIR 2003, Supreme Court Judgment 178. Okay, Bar Council of Andhra Pradesh versus Kurapati Satyanarayana. Okay, in this case, lawyer misappropriated his client's money. Okay, in this case, his lawyer, Kurapati Satyanarayana's lawyer, misappropriated client's money. Okay, BCA acquitted him on the ground that there was no intention. Okay, BCA acquitted him on the ground that there were no intention, but Supreme Court held that this decision of Bar Council of India held to be unfolded and preserved. Okay, this decision need to be unfolded and preserved, and lacking of serious thought which was required to be given to the disciplinary committee of the Bar Council of India in discharge of the discharge of quasi judicial functions while probing into such grave instances. In this case was discussed under Rule 23 and Rule 25 of Bar Council of India rules under Chapter 2. Okay, this is about Bar Council of Andhra Pradesh versus Kurapati Satyanarayana's case. Okay, moving forward to the next case. The next case we are discussing about is Shamburam Yadav versus Hanuman Das Khatri, AIR 2012, Supreme Court Judgment 2509. Okay, in the case of Shamburam Yadav versus Hanuman Das Khatri, the lawyer suggested that his client give bribe. Okay, his lawyer suggested to give bribe to the judge. Okay, it is a professional misconduct under Advocates Act. Okay, to the judge to get the suit decided in his favor, to get the suit to be decided in his favor. In this case, the Supreme Court held that the lawyer guilty of professional misconduct. As usual, no one should offer bribe to the judge. This is under Advocates Act 1961. Here, in this case, violation of Rule 3 and Rule 4 of Bar Council of India rules under Chapter 2. This is about the case Shamburam Yadav versus Hanuman Khatri, 2000 AIR 2001. The next landmark judgment we are going to discuss about professional misconduct under Advocates Act 1961 is Northanmal Chaurasia versus M.R. Murali, 2004. Northanmal Chaurasia versus M.R. Murali, 2004. 5 SCC Supreme Court number 869. Okay. In this case, the Supreme Court has held that the misconduct has not been defined in the Advocates Act 1966. As we discussed, there is no definition given for the term misconduct in the Act, but the term unprofessional conduct is being used in the Act. And as Supreme Court said, but the misconduct emphasizes breach of discipline. Remember the breach of discipline, although it would be It would not be possible to lay down exhaustively as what would constitute misconduct and indiscipline, in which, however, it is wide enough to include wrongful commission or omission, whether done or omitted to be done intentionally or unintentionally. Okay, here this is the landmark case about professional misconduct. Northanmal Saurashtra versus M.R. Murali, which says about professional misconduct, whether it is done intentionally or unintentionally. The next case we are going to discuss is about Narain Pandey versus Pannalal Pandey, 2013, 11 SCC 435. Okay, Narain Pandey versus Pannalal Pandey. Let's see this case. This case is about filing false wakalatnama and then complaining on behalf of false and previous compromises without authority. Okay, without authority of his client, he filed. An advocate who is found guilty of having filed wakalatnama without authority and then filing false and fictitious compromises on behalf of the client without any authority deserves punishment. Deserves punishment proportionate to the degree of misconduct. The PCI said such punishments must meet two objectives: deterrence and corrections. Deterrence and corrections must be met, and the court referred the preamble of Bar Council of India rules. In this case, the court referred preamble of Bar Council of India rules under chapter 2 while adjudging the misconduct. Okay, this is about the case. The next case we are going to discuss is about Harish Chandra Tiwari versus Baiju. Okay, Harish Chandra Tiwari versus Baiju. This case was in 2002, Supreme Court number 67. This case, client's money was misappropriated. Okay, misappropriation of client's money is a grave misconduct. Okay, misappropriation of client's money is a grave misconduct to be committed by a legal practitioner or advocate and must be punished. It is must be punished accordingly under Advocates Act. Okay, this case was under Rule 23 and 25 of Bar Council of Rules under Chapter 2. It was punished according to Advocates Act 1961, where there is a misconduct of misappropriation of client's money happened. This is a grave misconduct according to the Advocates Act 1961. So it was punished under Advocates Act 1961. The next case, Srimati Siya Bai versus Sitaram, Bar Council Trustee, case number 8 of 1987. In this case, the advocate withdrew the dissectoral amount paid and did not make any payment. Did not make any payment to the client. Okay, it is a professional misconduct. He didn't make a payment to the client. This case is a violation of Rule number 27 of Bar Council of Rules on the Professional Ethics. It is a violation of Rule number 27 according to the Bar Council of India rules. The Disciplinary Committee of Bar Council of India ordered the advocate to refund the money with 10% additional interest per annum. Okay, 10% interest per annum, and also ordered suspension of advocate for a period of 1 year. Okay, the disciplinary committee decided in this case that the amount to be refunded with 10% per annum and the advocate is suspended for a period of 1 year. So these are the top 5 case laws of advocate misconduct under Advocate Act 1961. Hope you like the video. If you have any queries, please leave it in the comment section. Please do like, share, comment and subscribe to LawPutra YouTube channel. Thank you.